Hey everyone, thanks for coming to the LawyerVid channel. It is very much appreciated. Please visit lawyervid.com, the fastest growing online video consultation platform for attorneys throughout all 50 states to make themselves available for members of the general public to conduct online video consultations. It is also the fastest growing referral network, something that you're going to want to be involved with. If you're an attorney, please sign up. And if you're looking for an attorney, please schedule a consultation and you will be directed to an attorney that is most suitable to your needs. Now, in this particular episode, I wanted to discuss something that you hear it oftentimes in the mainstream media, sometimes in high-profile cases, depending on which one, particularly the O.J. Simpson case. That's just one case. But you hear it all times, many others. And it's not always this type of application that this particular concept, this legal concept, is actually used or beneficial for a client. Sure, it happens, and it does happen where a person will have a previous conviction for murder or an acquittal for murder, rather, and then they are able to later raise the defense of double jeopardy in order to preclude themselves from being prosecuted for the same crime. And so essentially, that's what double jeopardy is. I think it's a pretty common knowledge what double jeopardy is among most people, that you can't be tried twice for the same crime. Now, there's obviously certain little like intricacies if the case gets dismissed or, they're allowed to re-indict, et cetera. But for the general rule, when it comes to double jeopardy, is that if a person is found guilty, they can no longer be tried for the same exact crime or anything that happened involving the same circumstances of the single action that they took, which led them to being arrested. So this topic came to mind because I see a lot about it with, stuff in the media. Like I said, O.J. Simpson, he wrote a book, I think it was called If I Did It or something like that. And in his book, he basically, he admits it without admitting it, basically that he was, in fact, the one that was involved in the murder of Nicole Brown Smith. And one of the cases that I actually wanted to discuss, which is very, very interesting, and it might be something that both a new practitioner, a new attorney who decides that they want to get into criminal defense can learn something from, and it could be very, very beneficial to a prosecutor who is handling what they think are misdemeanors. So this is how the story goes. And like I said, it's not going to be one of these where like the person was acquitted of murder and then they tried to recharge him with murder or something like that. It's not quite that dramatic. But you will see all of the same elements and how the case actually turned out to being a successful dismissal of the indictment based on the concept of double jeopardy. So in this particular case, my client had been previously arrested for 4 DUIs. So he had 2 DUIs in Michigan and he had 2 DUIs in Wisconsin. And then he was driving his vehicle one night and he got into a car accident and he rear-ended another vehicle. Police came. They obviously understood that he was intoxicated. He actually provided a breath sample, which was twice the legal limit, and he was arrested for DUI. So what's interesting about it, though, is that whoever it was, state, maybe, they didn't do their homework. They brought this case to the state's attorney, and what they said was that it was a misdemeanor because, again, his first 2 DUIs, 2 of his DUIs, they happened in Michigan, and then another 2 of them happened in Wisconsin. So what they thought was his first DUI in Illinois was actually his 5th DUI in Illinois, which makes it an aggravated DUI, which makes his minimum sentence 4 years, Illinois Department of Corrections. Not a very not a very great prospect for this individual. But, again, and I say this, and I say it just because it's the truth. If you want to practice criminal defense and you want to be effective at this, you got to be ruthless. You have to be willing to expose little holes. You can't provide unneeded information that is possibly going to get the state or the judge or somebody else to change their mind about the nature of the case and the nature of the character. So I knew, because my client told me, that he had 2 DUIs in Michigan and 2 DUIs in Wisconsin. So I knew that this was number 5 in Illinois. But I look at the state's charging doc, and they charge it as a first-time misdemeanor DUI. So what does that tell me? It tells me a lot. First, what it tells me is that we should plead guilty immediately to the misdemeanor DUI in Illinois. So what happened was, on the very first court date, we go there, say, Judge, we just want to enter a plea. We can continue the matter for sentencing, but we are just trying to get this matter over with. State's attorney shrugged, okay, no big deal. They want to run through their docket too, And so my client, he enters a plea of guilty to what he was charged with, misdemeanor, first-time DUI, okay? And the judge accepts the plea. That's the key word. The judge accepted the plea. So then he has to go get what's called an alcohol drug evaluation, okay? And that's basically to sort of define what the person's risk level and to find out what they're going to what they're going to have to do as a sentence, how many hours of treatment for their drinking problem. They'll usually have to go to a victim's, a Mothers Against Drunk Driving panel. There's just a number of different things that they usually make them do, sometimes community service hours, and then they have to pay a fine. But in any event, he pleads guilty on that day to misdemeanor DUI. The judge accepts the plea, and the matter gets continued for him to get his alcohol and drug evaluation, which he does. So I'm talking to him, and I told him, for one reason or another, I think I just didn't want there to be, I felt more strong in my ability in what I just did, that double jeopardy attached, and that there was no way he was being charged with anything else. So it didn't matter what he said to the alcohol and drug evaluator. I told him, I said, tell them, the alcohol and drug evaluator, even if they don't know, tell them that you got a DUI in Michigan, you got 2 in Michigan, and 2 in Wisconsin. He does. The evaluation comes back to the state, and on the very next court date, the state's attorney looks at the evaluation, sees that this is actually the guy's 5th DUI, and immediately wants to dismiss the case because they want to recharge him as a felon. So, because, he's looking at a 4-year sentence then as a felon. This wasn't his first DUI, it was his 5th. So I object. I say jeopardy attached. How could he be recharged? We already accepted the plea. Judge didn't care, because there's a certain reality that you're going to learn too sometimes when it comes to practicing law. Sometimes the judges are going to do things in a way that they feel is of fairness. The judge, I don't doubt he knew that jeopardy attached. He probably did know, but he probably figured that maybe if it got kicked down the line and it went to a felony courtroom or something like that, he might cop a plea to a lesser felony or something and maybe at least do some time and not be charged with a misdemeanor. So it wasn't the state filed a motion to dismiss the case, which is always very interesting because it's usually the defense that's filing that motion, which is actually an argument I made. I said, this is kind of a funny motion coming from the state. They want to dismiss their own charge. But the judge granted it. And he said that he was no longer going to listen to this case in the misdemeanor room, so he kicked it over to the felony room. Well, and then at that point, what I did was I filed a motion to dismiss the indictment based on double jeopardy. Now, what was the basis of that? Well, he had 2 prior Michigan DUIs, and he had 2 prior Wisconsin DUIs. State didn't know about him. And in Illinois, they charged him with a misdemeanor. So what I did was I let him plead to the misdemeanor, and I let that judge accept that plea. And when that judge accepted that plea, there's case law on this. You look at Illinois case law, you see what the law actually states. But when a plea is accepted, that's when they say jeopardy attaches. Okay? So plea was accepted, jeopardy attached. He can't be charged anything outside of what he was charged with. I remember this case was kind of funny because, again, I was a younger attorney. This was one of my first bigger, I guess you could say, motion case victories. And I mean, still had that ruthless mentality, which, you know what, that still comes out. I still have that mentality. I'll still win cases like this and not lose any sleep at night whatsoever. But the thing is, in this case, it was kind of funny because we did what was called a 402 conference. Now, a 402 conference is where you go back into the chambers with the judge and the state's attorney, and you talk about the nature of the case, So the judge knew that he had previously been in 4 other DUI incidences. This was number 5. He was automatically looking at a minimum of 4 years at the bottom. And she said, I'll offer him the 4 years. And my answer was no. No. Why would we take 4 years when jeopardy attached and he was charged with the misdemeanor, which only mandates a sentence up to 1 year, even if they were going to try to give him the worst on that point? And I remember the state's attorney, she was trying to bully me a little bit. She was a little bit older. So she was like, oh, our guy, he's looking into this. He's an appeals guy. He's a law guy. You're not going to be able to beat us on this motion. And I looked at her and I was just like, I'm a law guy. You know what I mean? Yeah, I was a young attorney, but it wasn't one of these things where I didn't know how to analyze a situation and analyze the law. It was just kind of funny trying to see a state's attorney sort of bully me a little bit just because I looked young. And so I said, no, not accepting the deal. We want to go to hearing on the motion to dismiss the indictment based on double jeopardy. Now, mind you have to understand a couple other funny things. This case had been pending now for a very, very, very long time because, there was all this motion practice, all this back and forth, a lot of different court appearances in between, a lot of discussions, et cetera, et cetera. So finally, on the day of hearing, go to hearing, the judge, reads the law. She cites the law that I put inside my motion. She writes her draft opinion. The case was dismissed due to double jeopardy. So this guy skated on his 5th DUI and a 4-year sentence simply based on the fact that I was shrewd enough to have him plead guilty to a misdemeanor DUI on the very first case that he went to court, knowing that the state didn't know that he had multiple DUIs outside of state. So, I'm not going to go to the state, hey, this guy has multiple DUIs outside of state. Is that helping my client by telling him that? No, it's not. Is it the right thing? Maybe. But again, if you're doing criminal defense, you're not necessarily doing the right thing. So one thing that was funny next was the court kicked it for what's called an appeal check. They wanted to see if the state was going to appeal the judge's ruling. Of course they didn't, because they knew that they were just done. They were done. And what they did try to do, though, which I thought was hilarious, they said, Judge, we want to recharge him now with misdemeanor driving under the influence, meaning to charge him with the first one that they had dismissed. Well, what was hilarious about that, I immediately objected on that. I said, Judge, respectfully, 18 months has passed, which is the statute of limitations on which he can be charged for misdemeanor driving under the influence. So this person walked away with 0 on his 5th DUI, all based on a technicality. He had twice the legal limit. He had terrible field sobrieties. I mean, there was absolutely no way this guy was winning this case. No chance. And just by the fact that I was able to exploit the fact that the state did not do their homework and they didn't look to see, hey, does this guy have outside of state DUIs? Because if he does, we maybe shouldn't charge him with the misdemeanor. I say this as a lesson in some ways, and not, well, a couple things. First, it was a big victory for me. I was so happy that I won this case just because it was like such a law case for such a young attorney to win on these grounds, you know? It wasn't the big double jeopardy based on, oh, he was previously tried with murder. It was something significantly smaller than that, but it was still very, very fun to win a case on law, on these legal principles. But I say this for defense attorneys. Pay attention to what they're doing because you exploit those mistakes and that's going to set you apart from a great defense attorney to one who's just mediocre, average, or just not even good. As a state's attorney, okay, don't lose your job. You guys have to, you should be checking every single time there's a DUI. Does he have out-of-state DUIs? I know you guys run your little sheet that looks like you're reading the Matrix, you know what I mean? And you see all the stuff that they have in Illinois, but what do they got outside of Illinois? You don't know. Guy might have 1 in Illinois, but he might have 10 in 10 different states, and you will never know it. And then next thing you know, you're charging a guy with a misdemeanor when he should be charged with a felony and probably doing jail time. So, like I said, I take this video, I show it sort of for the entertainment value. I sort of show it as a cautionary tale for new criminal defense attorneys and for new states attorneys to do your homework and pay attention to what you're doing. Because if you don't pay attention to what you're doing, a guy like myself is going to come in there and I'm just going to tear it up. And I'm just going to make it look easy. So thanks so much for watching the video. I really, really appreciate your support for this channel. Please visit lawyervid.com, check out the platform, and I hope you have a wonderful day.